principle that I'll be using is enacted in section 39, subsection 2 of the Constitution and deals with legislative interpretation of the Constitution and states that when interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and the object of the Bill of Rights. And the case that I'll be relying on is Jordan versus City of Tshwane Metropolitan Municipality. At paragraph 8, the court held that if the matter involves the interpretation of legislation in conformity with the constitutional imperative and best promotes the spirit, purport, and the object of the Bill of Rights, then that matter raises a constitutional issue that engages the court's jurisdiction. I'll be going to the third principle, but before I do that, we are not saying that the interpretation of legislation necessarily gives rise to a constitutional matter. But in the context of section 39, subsection 2, the court finds jurisdiction because the interpretation of legislation implicates a right. If the interpretation of the legislation limits a constitutional right, then the interpretation of the legislation raises a constitutional matter under section 39, subsection 2. Then I'm going to the third principle, the exercise of power. The reviews of administrative actions are constitutional matters for this reason, and because these reviews are brought under CATA, which is a constitutionally envisaged legislation. I'll go to my fourth principle, which is also on section 39, subsection 2, which deals with the constitutionally envisaged legislation and legislation implementing rights. The interpretation and application of the legislation that either A is constitutionally envisaged or gives effect in a constitutional right is a constitutional matter. Going right along to my fifth principle. My fifth principle will be dealing with the fair procedure of the court's power. Here I will be relying on section 34, which states that, section 34 of the Constitution, which states that, and I read, everyone has a right to have any dispute that can be resolved by application of law, decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. I will rely on the Telecordia case, whereby the Supreme Court of Appeal held that inter alia, that private arbitration as a starting point falls within the ambit of the section 34 of the Constitution. It was also noted that it was in accordance with the approach in the European Court of Human Rights, and that is Slovenia versus Finland. Also, the court does have jurisdiction because it raises the constitutional issue. And section 21, subsection 1F of the Arbitration Act 49 of 1996 here stipulates that the court has the same power to make orders in respect of the interim interdict or similar reliefs. Going to declaratory order, which is the appropriate remedy that you are seeking before the court. We want to declare that Rule 8 of Chapter 4 of South African Federation of Swimming Domestic Rules and Regulation unconstitutional and invalid, in that it infringes the swimmer's right of freedom of expression under Section 16 of the Constitution. In terms of Section 21, subsection 1C of the Superior Court Act 10 of 2013, the court has the jurisdiction to grant this order. The Supreme Court in Cordia Trading, CC versus Daimler Chrysler Financial Services, it held that the existence of a dispute between the parties is not a prerequisite for the exercise of the power of the court. In terms of Section 19, subsection 1, Roman figure 3, which is a predecessor section in this act, it stated that what is required is the existence of the parties on whom the declaratory order would be binding. Content JA on to confirm the two-stage approach adopted in Watermere, JA in Durban City Council versus Association of Building Societies, to say that the court must satisfy itself that the applicant is a person interested in an existing, future, and contingent right or obligation. And then if it is satisfied on that point, it has to go on to determine whether the case is a proper one for the exercise of its discretion conferred upon it. In other words, whether the applicant has an existing, future, or contingent right or obligation is a condition precedent for the court to exercise its discretion, whether to grant the declaratory order that is so or not. Given that we have given the existing rights, that if this remedy is not approved, the applicant's right, section 16, which says that there is a right to freedom of expression, it would be infringed. Also, as I stated before, that it is a condition for the court's exercise of its discretion. It follows that once it has been found that the applicant does not have an existing, future, or contingent right or obligation, the court should refuse the declaratory order without going to the second leg of inquiry. Thus, in any application premised on section 21, subsection 1c, the court must first determine the interest of the application. We therefore submit that the applicant has established existing and future rights, and also he has established the respondent's existing and future obligations. These are derived from the applicant's rights that are found in the Constitution. I'll go on to sum up everything. Therefore, the applicant concludes that the constitutional rights of the applicant has been infringed by the rules and conduct of the respondent. Rule 10 does not constitute an internal remedy insofar as the Promotion of Administrative Justice Act is involved. The human rights is only appropriate court which may adjudicate on the current dispute between the applicant and the respondent. The applicant requires the cost of this litigation to be declared as per the Viovac principle. The respondent will have to tender the cost of the litigant on behalf of the applicant. The applicant prays for the court to rule that the current dispute between the applicant and the respondent should be adjudicated within the Human Rights Court, reviewed and set aside. The applicant further prays for the court to rule that the dispute should be adjudicated upon by the justices of the Human Rights Court. The applicant further prays that the court finds that the conduct of the respondent infringed the constitutional rights of the applicant. The applicant further prays for the court to find that Rule 10 of Chapter 2 does not constitute an internal remedy in as far as partial is concerned. The applicant further prays for a cost order against the respondent. The applicant lastly prays for any further and alternative remedy that the court may deem fit. Thank you.
Thank you, Counsel. Thank you, Counsel. Just one question instead of clarification. You heard the debate between your lead counsel and the bench, and he agreed. He agreed that what is before this court at this stage is actually an application for leave to appeal against the order that was granted by the High Court, which was confirmed by the Supreme Court of Appeal. So essentially, what this court has to do, and you will tell me whether there is an agreement or not, is to determine, and you have made some submissions in that regard. You have submitted that it is in the interest of justice for this court to hear the matter. So the other leg that you have to address, of course, would be the prospect of success, because we are now dealing with an application for leave to appeal, and you would also be asking this court to entertain the merits of the matter on the basis that there are grounds for granting it. Am I correct in this summation? The reason why I'm asking is you at some point alluded to a declaratory order. So I just need to confirm with you